Thank you so much, Professor Masako, for inviting me for this talk. I'm Neha Vyas. I just finished my PhD last year from Goethe University, and now I'm working as a lecturer in commercial law at Newcastle University in the UK. And I have I have quite a lot of interest in competition law because I authored a book just 2 years ago. So it's the next week would be the 2 year anniversary of the book that I published. And it was a great opportunity that Masako gave me to provided me a platform to discuss the book, as well as a lot of topics that to be covered in the in the Indian competition law and policy. And this talk couldn't have come at a better time, because for those who are aware or of the developments in the Indian competition law and policy, the president just gave assent to the Competition Amendment 2022 bill, which is quite a feat because it was 4 to 5 years underway, and that just happened in April 2023. And with around 60 amendments have been added to this. So I've tried to incorporate these amendments within the structure of the Competition Act 2002, which I'll discuss at length in this presentation. So at the time of my meeting with Masako, I realized that although India has rapidly adopted digitization and has been bringing up policies and bills on the topic, very few competition lawyers in the international forum are aware about the historical shift and the mechanisms and the structure of Competition Act. So in this presentation, I'll provide highlights of the historical transition of from MRTP to Competition Act, that is Monopolistic Restrictive Trade Practices Act to Competition Act. And I'll briefly also touch upon recent case laws and amendments. So to start with, this is the book that I published, and which was mostly for competition law practitioners in India, and fortunately has been well received in the community, in the competition law community in India. And this is the structure of the book. So I have mostly included not focused completely in the book on the case laws, because it is quite important to discuss the concepts of the economics of competition law, because the concepts like market definition, market power, and entry barriers are more pertinent than merely discussing case laws. I've also included the perspective from the US and the EU, because as you must be aware or not, competition law in India is quite young. The CCI as a regulator is just 13 years old. So we had to incorporate a lot of cases or take precedents from the EU and the US. So we rely heavily on other jurisdictions, and I've covered that in this as well. So now, starting with the historical trajectory of competition law in India. So after the independence, we had a command and control economy, also known as the Nehruvian model, which means that private and public sector did coexist, but there was more control and supervision on the private sector, and which was being done through the Industrial Development Regulation Act of 1951, also known as License Raj, because the private industries had to get license from the government. So in 1955, to assess the efficacy and the viability of industrial licensing, the government appointed a Hazari committee, and the findings of the report showed that there was a disproportionate growth of big business houses in India, and thereby marginalizing the small and medium enterprises. After that, there was Mahendra Lobis committee, which was formed to gauge the distribution and levels of income in the country. And again, the results showed that the big business houses were flourishing, and that 10% of the population had accumulated around 40% of the wealth. So there was a lot of concentration of economic power. Thus, the Monopolies Inquiry Commission was set up to gauge the anti-competitive practices, as well as the concentration of economic power in the industry. And the result was the Monopolistic and Restrictive Trade Practices Act of 1969, which finally gave legitimized monopolistic trade practices, restrictive trade practices, and unfair trade practices in India. After that, even till 1991, mostly it was the public sector which was ruling, but after 1991, that is liberalization, privatization, and globalization movement in India, the as well as the WTO and other international obligations. To fulfill those obligations, India had to set up Raghavan Committee, that is also the high level committee on competition and policy. And this is quite crucial because most of the, so this report runs in 2 volumes of around 300 pages, which documents evidence from as well as legislative framework from the UK, the EU, and the US in order to guide or introduce new concepts which were not known in the Indian competition realm, like merger control regime and competition advocacy and such. And so this was quite futuristic and had a drastic shift of competition regulation in India. And then we had the Competition Act of 2002. So even though we had Competition Act been formulated in 2002, this Competition Commission was set up in 2003, but only was effective or the enforcement powers were only given from 2009. So it's just 13 years since the establishment or the workings of the Competition Act. Just to briefly touch upon the constitutional framework, which enables in India, which enables the competition policy or formulation of the Act, is fundamental rights of Article 19 1G, which states right to carry any occupation, trade, or business. But I'm sorry. Is it possible to? Okay. Yeah, so for Article 19 1G, right to carry any occupation, trade, or business, but it comes with reasonable restrictions. And due to those reasonable restrictions, 302 read with 304B empowers the Parliament to enact any legislation to reasonably restrict the freedom of trade. We also have DPSPs, which are not binding, that is Directive Principles of State Policies, not binding, although we do state that to secure social order of the welfare of the people and to prohibit concentration of wealth. So this is the constitutional framework which gives effect to the competition policy and law in India. So now going to MRTP Act, there were three main practices or conducts which were prohibited. It is monopolistic trade practice, restrictive and unfair trade practice. So MTP included basically if you can see that limiting technical development or capital investment, this is akin to abuse of dominant position, like the provisions under abuse of dominant position. However, dominance itself was considered as a bad conduct on the enterprises. So for instance, on the basis, so whether an undertaking has a share of 1/4 or more in the production, supply, and distribution or control of goods or service was blanketly been stated as a dominant position. So there was no, it was based on the size rather than the conduct of the enterprises. So which has been changed because now only abuse of dominant position is being considered problematic. RTP, if you see the practices listed here are akin to anti-competitive agreements with vertical and vertical agreements. So that is tie-up, sales, refusal to deal. So this is more like vertical agreements. And here, under Section 33 of the MRTP Act, all the agreements were to be registered with the RRTA, that is registered of restrictive trade arrangements, so agreements. So irrespective, so it was just, if you can look at it, for MTP and RTP, there was just per se rule, there was no rule of reason, and thereby agreements, any agreements need to be, agreement needed to be registered with the authorities. UTP is like unfair trade practice, is bargain sales, bait, switch selling and misleading advertisements. Now that is considered covered by Consumer Protection Act. So until 1984, the MRTP Commission was dealing with unfair trade practices as well, because we did not have Consumer Protection Act, and now that has been diverted to the Consumer Protection Act of 1986. So UTP is now no longer dealt with in the Competition Act. So why did we need to shift from the MRTP to Competition Act? First was the insights from the Raghavan Committee report because of the international obligations as well as the pressure to have pro-competitive goals and not just to curb monopolies. We needed to enhance or to advance our competition policy in India. Secondly, per se rule and rule of reason, which was quite absurd, honestly, because in MRTP Act, most of the agreements were considered presumed to be illegal unless otherwise proved. But interestingly, in this telco case versus RRTA, which was in 1977, the Supreme Court gave three factors, and that was the onset of the rule of reason in India, wherein the Supreme Court stated that there are three factors to be considered before blanketly stating any agreement to be restrictive, and that was that what facts are peculiar to the business to which the restraints is applied, what was the condition before and after the restraint is imposed, and what is the nature of the restraint and the actual and probable effect. So basically, the rule of reason in the sense that considering the facts of the case as well as considering the relevant market, the geographic and product market, this needs to be shall be determined whether any agreement is anti-competitive or not, and you cannot blanketly state that any conduct is anti-competitive. So the rule of reason was first introduced in this telco versus RRTA case. Uh, Again, another reason to have to shift to Competition Act was extraterritoriality. So we lost a case like the ANSAC case, the American National Soda Ash case, um, because MRTP Commission did not have extraterritorial power. So now in Competition Act, we have introduced Section 32, which deals with extraterritoriality, and now it is in line with the EU, US, and Japan. Although, of course, under Section 3, subsection 5, the export cartels originating in India are excluded. So to give a recent example, there was an after the leniency application filed by an automobile component manufacturer based in Japan, along with Indian subsidiaries, the CCI started investigating into those subsidiaries, and then JFTC investigated the anti-competitive agreements between the parent companies in Japan, and then CCI covered the period up until the date on which CCI carried out, JFTC carried out investigation. So that means that up until that point, CCI did exercise the extraterritorial jurisdiction because the conduct or the origination of the agreement and the practice was in India. So this is just one example of a suo motu case by CCI on extraterritoriality. We also did not have competition advocacy in MRTP under MRTP Act because it was quite bent on regulating or restricting monopolies and not in promoting competition or pro-competitive goals or consumer welfare. So then we introduced competition advocacy in Competition Act, so as to include stakeholders to look at the competition policy and to take their opinions as well. And we started with raising awareness amongst the stakeholders. Another factor which we already discussed is dominance to abuse of dominance. So dominance itself was bad, and then we shifted from that to the abuse of dominant position to get in line with the international legislative framework. And merger and control, surprisingly so, because we did not have any merger control regime, or especially prohibiting certain mergers which have appreciable adverse effect on the competition in India. So we introduced the merger control as well. So these are the reasons to shift from the MRTP to Competition Act. Now, this is the legal framework. So we have the main legislation is Competition Act 2002, and then we have combination regulation, wrestle penalty regulations, regulations on fines, and so on and so forth. So the objective of competition law in India, which is also stated in is to promote and sustain competition in markets. So we have this concept of appreciable adverse effect. So if any agreement, so this goes for anti-competitive abuse of dominance position as well as on combinations, because it's called merger control or combinations, having appreciable adverse effect on competition will be considered as which should be prevented. And As we go on, I'll explain what appreciable adverse effect means for all these sections. Then to promote and sustain competition in the markets, protect the interests of the consumers, and to ensure freedom of trade carried on by other participants. These are the salient features of the Act. So we have three substantive provisions, which we'll discuss at length. That is prohibition of anti-competitive agreements, abuse of dominance position combinations. CCI, as I mentioned earlier, established in 2003, but effective only from 2009. So the enforcement provisions were only from 2009. There has been a case, actually a Kingfisher case, where so usually when a provision comes into effect, only from then for a forth you can the cases can be dealt with by the commission. But in the case of Kingfisher, there was also a case wherein the the conduct was prior to 2009, but it was still given the jurisdiction. The CCI could still deal with it after 2009. So that was an exception which is made, which is not so, like the retrospective effect is mostly not given in these cases, but the conduct arose before 2009, but CCI still had the jurisdiction and gave judgment after 2009. Competition advocacy and constitution of competition fund, for which comprise of penalties, and it's used for raising awareness and so on. So this is the institutional framework. So sorry. So Competition Commission of India is the adjudicating authority. Office of Director General is the investigative authority, and CLAT. And now this is interesting because recently I have been discussing on this topic, that is how procedural and flaws and technical glitches leads to setting aside of cases, and thereby leaving a lot of companies can get away even though they are engaging into anti-competitive agreements. And NCLAT and COMPAT is quite an interesting case because till 2016, the appellate authority was Competition Appellate Tribunal, and now it has been replaced to National Company Law Appellate Tribunal under the Companies Act. The reason for that was because it was considered that COMPAT was overstepping adjudicatory boundaries and was being rendered ineffective, in the sense that it was setting aside various cases of CCI on the basis of for not adhering to principle of natural justice, and thereby losing the opportunity to reprimand anti-competitive behavior. One case is GAIL, that is Gas Authority of India Limited, wherein they were accused of abuse of dominant position, but the CCI was being COMPAT considered CCI as being overly diligent in passing a prima facie order. So usually for a prima facie order, COMPAT mentioned that you should only consider do preliminary analysis and should not, let's say, contain detailed examination of allegations or evaluate evidence and record its findings. So, so that part, that is recording evidence and so on, and the detailed investigation should only be carried out after the DG completes, the Director General completes its investigation. That was the contention of COMPAT, and that thereby they set aside the case, even though GAIL was the prima facie evidence suggested that there should be further investigation. There was another case, that is the Uber case, wherein COMPAT, wherein CCI's prima facie decision to close the matter on abuse of dominant position and anti-competitive agreement was opened by the COMPAT, and then COMPAT directed the DG. Usually the CCI directs the Director General, but in this case, COMPAT directed the Director General to start a fresh investigation. So these are the instances which blur the boundaries as well as the architecture of the authorities that or the powers being given to both the authorities, because appellate tribunals have certain powers. Sure, their power can be broad in nature and they can in certain circumstances direct the DG, but that shouldn't be considered as the norm. So a lot of cases were being set aside for this. Another example is International Air Transport Association, wherein Compat again directed DG to initiate a fresh investigation and dismiss the findings of the CCI. In Uber case, when CCI did set aside the case, did state that there is no abuse of a dominant position or anti-competitive agreement, then the compact opened the case, and then Uber filed a case against Supreme Court by stating that there is an issue with the jurisdiction. So these are the issues which led to render this compact ineffective. And now we have NCLAT. Surprisingly, in until last year, there has been no case where CCI or DG's cases or investigation has been set aside on the basis of principle of natural justice. Although in 2022, finally, after 9 years in a tire cartel case, NCLAT finally set aside CCI's order of because there was an arithmetical error in calculating the market concentration power. So that is the only case that I can come up with. Maybe there are more, which states that NCLAT had set aside CCI's decision in a matter which was so regarding, like, let's say, arithmetical errors or so on. So now we have NCLAT, and so there is a stark contrast between NCLAT and compact. The divisions are so secretary and secretariat are for administrative powers, for administrative decisions, and the divisions are antitrust divisions, advocacy divisions, abuse of dominant divisions, and so on. So these are the substantive provisions under Competition Act. These are quite similar to Treaty on the Functioning of the European Union, Article 101, 102. So we have prohibition of anti-competitive agreement, Section 3. Section 4 is abuse. So that would cover horizontal and vertical agreements. Abuse of dominance, that would be Section 4, which includes predatory pricing and limiting the control of limiting and controlling supply and distribution and so on. And then we have regulating combinations. So combinations would include controlling voting, powers, shares, also includes mergers and amalgamations and acquisitions. So Section 3, subsection 1, yeah. So no enterprise shall enter into an agreement causing appreciable adverse effect on competition, otherwise void. So appreciable adverse effect in every case is different, and Section 19, subsection 3, for instance, in under Competition Act, gives certain factors listed from A to F, which the CCI and all the adjudicating as well as the appellate tribunal should look into before while investigating into horizontal and vertical agreements. Is accrual of benefits to consumers, creating barriers to new entrants, foreclosure of competition by hindering entry into the market, and so on. So these are the factors listed which CCI should take into consideration. Section 3, subsection 3 is horizontal agreements. For horizontal agreements, we still have presumption of illegality. Although in one case, in Globe Mode Travels versus Travel Agents Association of India case, it was mentioned that presumption of illegality is rebuttable if the parties prove pro-competitive effects. So yes, there is presumption of illegality, but if it is for pro-competitive effects, it can be proved. Section 3, subsection 4 is vertical agreements. So you can see the difference between RTP being dealt with in MRTP, and now here it's been judged by rule of reason. So there is no presumption of illegality. And so I'll just deal with cases which talk about plus factors, in the sense that in the cement cartel case, usually you have to prove AAC and circumstantial evidence, because there is a presumption of illegality. There is direct evidence is not a necessity, and circumstantial evidence can be considered while adjudicating the case. So in the cement cartel case, there were 11 companies, cement manufacturers, that were held in violation of fixing the price, as well as determining the purchase of and limiting or controlling the production. And the CCI mentioned that the circumstantial evidence was enough, and factors such as sharing of information amongst the 11 manufacturers, which facilitated price fixing and giving identical rates, after a certain meeting, that kind of evidence is just a plus factor. So usually you would presume illegality or consider that there is an anti-competitive agreement, and these factors which give direct evidence in any way are plus factors. The same was an Excel Corp case for collusive bidding, where there were four manufacturers who colluded amongst themselves to fix the rates. And it was observed that the oligopolistic characteristics of the industry, because there were only four manufacturers of, was it? I think it was, yeah, aluminum phosphide tablets. So in this chemical industry, there were limited manufacturers, and despite having different costs of production, geographical locations, and profit margins, these manufacturers had quoted the same rates, identical rates, not same, sorry, identical rates. And that's why it is considered this circumstantial evidence that oligopolistic character and so on is considered in itself as being collusive bidding, and you do not need any plus factors to prove otherwise. This case is also interesting because, so I have highlighted red for all the amendments that are being introduced. And in this case, the companies were were asked to pay. So here, as you see, penalties for cartels is up to 3 times the profit, or 10% of the turnover, right? And here it was interpreted as a relevant turnover. But now, through the amendments in April, they've changed it to global turnover. So yes, so while imposing penalties, so that it's contentious, it could be contentious and amendments, but now it provides global turnover to calculate the penalties, and fines will increase. And of course, there will be guidelines on these fines later on. There is high penalty risk now. So this case, it was relevant turnover, but it was quite contentious. So now the amendment states global turnover. So we also have leniency provisions. So Section 46 talks about full, true, and vital disclosures uh, can lead to lesser penalty, and the lesser penalty regulations also talks about how to avail such benefits, the procedure for grant of lesser penalty, and the content of immunity under leniency provisions. Now, through the amendment, we have also introduced leniency plus, which empowers the CCI to grant additional leniency in a penalty situation where a party being investigated for collusive conduct makes a true and vital disclosure of another undisclosed cartel. It also talks about how to the withdrawal of a leniency application by the applicants. So leniency plus now adds, yes, in the say, if you are applying for a leniency application, but also for an undisclosed cartel, if you can, if thereby encouraging whistleblowers in case of cartels. The CCI is so now the amendments also bring in non-competitors into the scope of cartels. So non-rival firms who either participated in a cartel or are intending to participate in a cartel can also be penalized. So we have now finally formalized hub and spoke cartels through this amendment, which was not the case before. Okay. So the exception to Section 3, subsection 3, that is horizontal agreements, is joint ventures. And so this only applies to anti-competitive agreements and not combinations. So in case of merger control, they are still the joint ventures are still liable if they cross threshold limits. So this is just for anti-competitive agreements. If a joint venture increases efficiency in acquisition, production, supply, and so on, there is no blanket immunity, but it does raise a presumption in favor of the JV. For instance, in health insurance third-party agreement JV case, where there were 4 PSUs, there was an efficiency enhancement in the public sector insurance sector. Similarly, in another case, that is Z-Star case, CCI said that there was no foreclosure on account of the JV, and also considered a market-specific feature of a highly regulated market like broadcasting and media. So taking that into consideration and promoting pro-efficiency, the CCI did go in favor of the JV case and did not state that outrightly there is no per se illegality in this. It can be considered as an exemption, but there is no blanket immunity. So this is the same as regarding the efficiencies defense, which has been taken in 1013. There's still not been any case of liability of parents of the acts of the JV. So there is no case on the single economic entity so far in India. So, for instance, EU has this operational autonomy test under the merger regime, and a fully functional parents liable to for JV's competition law violence if they exercise strategic influence over the JV. So, for instance, the Dow Chemicals case and the chloroprene rubber rubber case, and also LG Electronics case in 2015 in the which stated the liability of parents of the act of the JV is there's nothing, no such case that has been brought into brought in front of the CCI as of yet. But yes, the JV is an exception here. So this is just section 3, subsection 3, price fixing. These are the 4 topics that are covered in that, and now they have added hub and spoke cartels, sorry, and vertical agreements are refusal to deal. So the definition is given within the act of what would constitute as all these factors. The second is abuse of dominant position. So section 4 deals with read with section 19, as I mentioned that uh, the appreciable adverse effect on competition differs in every case. So here it includes predatory pricing, denial of market access. I think that is the same as in the EU as well. So if there is a potential to foreclose the competition by creating anti barriers, and there are exclusionary and exploitative abuse, which is dealt with under abuse of dominant position. There are a lot of cases recently on this topic, especially in digital markets, and a lot against Google, which is not surprising given their violations in every jurisdiction. But I would just deal with a few of them. So there was a case wherein recently in 2022, CCI imposed a penalty of 9.36 billion rupees on Google for abuse of dominant position in market for licensable OS for smartphones, and in the market for App Store for Android. So the CCI observed that the Google had abused its dominant position in the market for the licensable mobile OS system for smart mobile devices, and the market app stores for the Android OS. And together we fight society. So recently CCI has also started suo motu investigations, as well as investigations by public spirited individuals. So I would say that we'll come to the procedure, and I'll mention that who can file the information memorandum. But so together we Fight Society is an NGO that brought a case, that filed an information memorandum against Apple by saying because Apple was using a barrage of anti-competitive restraints and abuse of dominant practices in markets for the distribution of applications to users for smartphones, tablets, and processing of consumers' payments for digital content used within iOS mobile apps. So this is about the in-app content in which it's supposed to be Apple is supposed to be conducting having a violation of Section 3 and Section 4 simultaneously. So it's still pending because it's an ongoing investigation. So CCI did accept this and started an investigation against Apple. WhatsApp privacy case, this is quite interesting because it is first of its kind, it's in India especially, for an investigation into non-price factor for abuse by an alleged dominant entity. So in its prima facie view, the CCI pointed out that WhatsApp's new privacy policy was imposed on users mandatorily. So the policy allowed WhatsApp to share data with Facebook, and the CCI ordered an investigation for want of consumers' consent in WhatsApp's actions that gave no choice to consumers, as WhatsApp was tentatively considered to be dominant in the market of instant messaging. Now we still do not have data protection bill. So this is quite an advancement in the sense that competition authority is taking a charge in the privacy case by looking into non-price factors and considering that as falling within the abuse of dominant position in the within the purview of abuse of dominant position in the act itself without even the amendments being introduced as of now. There's also another case on digital news. So the informant in this case argued that Google imposed direct and indirect unfair conditions on the members of the informant, and while allowing website links of the members of the informant on their search engine results. So in their prima facie order, CCI found out that from 2019 to 2021, Google's market share in the search engine market ranged from 98 to 99%. And that is the reason to initiate this investigation, because to consider whether, I mean, there is an abuse of dominant position in the news or the media market. Yeah. And so within the section, we also have the factors to be considered. Of course, there will be other factors that you will be considering in digital markets, but we have factors determinant of an enterprise's dominant position, which would include size and resources, size and importance of competitors, and so on. There's geographic market from A to H listed, consumer preferences, local specification requirements, national procurement policies, and so on. And factors to determine a relevant product market from A to F. This is again covered under section 19, which is exclusion of in-house production, classification of industrial produce, and so on. I hope I'm not going beyond. Okay, it's been just 45 minutes. Okay. So now coming to the combinations and merger control. So section 5 and 6 read with section 20, subsection 4 deals with combinations and mergers. Surprisingly, we don't have the provisions like the UK. We have mandatory and suspensory regime in the sense that if there are certain thresholds which are being, which I'll cover in the next slide, are being crossed, then in that case, you are supposed to file, the parties, the acquirers, the parties are supposed to file a combination notice. And the combination regulations of 2011, which have been amended a lot of times, by the way, are state the procedure to do so. So there is also pre-filing consultation, which is an oral and non-binding and informal, in the sense that if someone wants to know, if a party wants to know if they can go through a green channel route, that is a speedy process or not, this can be done. And it is compulsory, otherwise the parties will be penalized, which is quite good because ex post review can be quite problematic and at least in my view. So this is a great provision to have in the in Indian competition law. So what is considered as combinations would be acquisition, acquiring control, shares, voting rights, or assets of an enterprise, and any merger or amalgamation. So now the definition of control in the amendment has been diluted to material influence. So now it's not just so even if there is so enterprises that are short of decisive influence will also come under the purview of combinations. So that is like broadening the scope of combinations. So this is quite vigilant in a sense. And appreciable adverse effect, again, for which is under section 20 for combinations includes extent of effective combination likely to sustain in the market share in the relevant market, and so on. This is the threshold limit. Just to say, crores would be the 2,000, greater than 2,000 crore would be 245 million US dollars. Now, the threshold limit, there has been a deal value threshold limit which has been introduced. So apart from 245 million, as you can see, the 2,000 in the first place, that is 2,000 crores, it is also includes 245 million plus substantial business operations in India. So that is, so I have covered. So this is the threshold for filing the notice. And there is a deal value threshold where 245 million US dollars plus substantial business operations in India. So I think here Indian the CCI the authorities are still pending. The regulations still haven't been amended. It has still been is still under the process. So I think here you can take example of, for instance, in Germany, the regulation, the guidelines on significant domestic operations, which was introduced in 2019, that could be beneficial to take example while setting up the substantial business operations in India. Sorry, criterion. There is phase two where so there's a short form. It depends on the combination, the type of combination. There's a long form, which is phase two, and the review period has been decreased from 2010 to 150 days. This is also the ease of doing business policy of India. That is, so the government is trying to minimize the bureaucratic timelines, which can increase efficiency. So this is a part of that. We have also introduced green channel, green channel route. So a combination is deemed to have been approved upon filing the notice in the prescribed format and acknowledgement thereof, subject to the commission's finding that the combination falls under green channel route. I have a table on, because Masako was quite interested in knowing the statistics of cases being dealt with CCI. So I've included it in the end. And the green channel route so far has been quite effective and efficient. So this is a good provision under the Act, and it promotes speedy, transparent, and accountable review of combination cases. Now, so we had a lot of gun jumping penalties, as you can see, amounting to 1 million to 5 million rupees. But we have, through the amendment, we have introduced open market purchases, so which can be done prior to the receipt of CCI's approval, so long as the CCI has been notified. The parties seek approval of the CCI for the acquisition within a time frame which will be specified in the regulations, and the ownership or beneficial rights associated with the shares are exercised only post receipt. So that would decrease the gun jumping penalties. So again, an efficacious amendment provision that has been introduced, open market purchases. There are sector specific exemptions. So from time and again through Gazette notifications, CCI tries to exempt certain sectors for a certain duration of time. So amalgamation of, for instance, regional rural banks is one of the exception. And then after that period of time, they are again liable to give notices under combination. So it's a window period that is mostly provided by CCI. The recent cases on merger control would be definitely Facebook and Reliance, because it was approved, and then there is likelihood of issues. So for instance, the CCI approved acquisition of 9.99% equity share capital by a wholly owned in Reliance Jio. So it's a big digital, it has a big share in the digital market in India. And CCI approved 9.99% of equity share capital by a wholly owned subsidiary of Facebook. So an interesting aspect of the collaboration was the commercial arrangement with the instant messaging app platform WhatsApp, wherein in relation to connecting users with Reliance's new e-commerce marketplace, that is JioMart. So there were issues about where CCI did consider that data-backed market power should be considered, but still approved it and left it to ex post review, in the sense that if any kind of anti-competitive or sharing of complementary data happens, so we'll see it at that point of time. This could also be influenced a bit politically, but but it has been approved finally. There were also issues about net neutrality in this case, and that was left to TRAI. So we have this issue of sectoral overlaps, which is quite not clear. And TRAI is the Telecom Regulatory Authority of India, which also deals with anti-competitive practices in the telecom sector. And while approving this acquisition, CCI stated that that has to be dealt with by TRAI, and it could be done ex post or at the time that any such anti-competitive behavior is seen under this combination. We also have Hyundai Motor, and this was quite interesting because the strategic agreement between the parties piqued the CCI's interest because of its algorithm, because they were using, so there was a combination of Hyundai Motor and then Ola. So CCI had thought that hypothetically it could promote the use and leasing by Hyundai of Hyundai cars amongst Ola drivers. But in response, there was a voluntary notification, a clarification sent by both the parties by stating that the strategic collaboration is not is non will be on a non-exclusive basis. So they will not be. So there is no problem of like exclusive dealership or using Ola's algorithm to promote Hyundai cars leasing of cars amongst Ola drivers. This is another case. Another. This is a procedure of investigation by the CCI. So CCI can initiate investigation in three ways: suo motu by direction from central government, and an information memorandum filed by a person as defined under the act, by a consumer, by consumer associations, and by trade associations. So there is a scope of class action suit in under Competition Act, in the sense that so that it prevents, let's say, the multiplicities of cases in which parties with the same interests are seeking similar relief. So this lessens the burden of cases in with the CCI and the appellate tribunal. This is for both CCI and NCLAT. Class action suits are allowed. Then CCI formulates a prima facie opinion as and then decides whether it needs further investigation or closure. If it does need further investigation by Director General, then uh, they will. So the Director General has the power given under Civil Procedure Act in India. So that would be summoning and enforcing the attendance of any person, then requiring discovery or production of documents, receiving evidence on affidavit, and so on. So there have been, so usually DG cannot initiate an investigation, of course, but the the scope of DG's power have been widened through case law. So in Mahindra, in these cases, um, it was decided that the, even though they cannot, the DG cannot initiate an investigation, but the investigation is not limited to either the parties or the issues mentioned in the information memorandum. So previously, and this has now been added, I think, I'm not aware of the year, but it's been 2-3 years since when this has also been added under the regulations. So now there is an amendment. So the NCLAT said, so DG's investigation, the issues and the parties, the scope can be broadened. And the DG issues the report to CCI for no violation, further investigation, or violation. CCI is not bound by the findings of DGI. In this case, India Motor case, so NCLAT decided to set aside CC's order on the grounds that CCI had solely relied on DG's report and failed to conduct an independent inquiry. So the CCI is obligated to conduct an independent inquiry and should not rely only on DG's investigation report. So this is under section 19, read with section 26. Composition of CCI is one, there should be one chairperson, minimum 2, maximum 2, maximum 6, and appointed by the central government. And so in MRTP Act, the chairperson of the MRTP Commission was solely decided by the central government. And now in the Competition Act, we have a selection commission that would have a say, while whose opinion should be considered by the central government before appointing chairpersons and the members of the CCI. And DG is appointed by the central government, but through the amendment in April, now CCI, it's subsumed with CCI. So CCI is empowered to now appoint the Director General. Now, I don't know if this is a good amendment or not, but yes, that has been the amendment introduced in April. The competition advocacy, which is introduced, so under section 49, the state government has the CCI to input on, so this has been used quite frequently these days because there are a lot of seminars, conferences, even interactive sessions with experts, with economists, and so on, to inform the competition policy. And I think this is quite essential given the digitization and how algorithms work, and how mostly lawyers are not that aware of the mechanisms of such algorithms. So I think this is a good step, I would say, and it has been dealt with advocacy division. Again, Raghavan committee report was quite substantive in the sense that it included all these futuristic problems that the that might be encountered, and that's why there are these kind of provisions to promote competition awareness and impart training on competition issues. And lastly, so I have included all this, and it will be a phased enforcement via notifications. And so my conclusion would be that CCI has been a proactive regulator. There have been market study reports on e-commerce, telecom sector, and pharmaceutical sector, and the recent one was on surge pricing in the cab aggregator sector. There have been dawn raids recently on in the sector of construction, pulses, and the manufacturing sector. And CCI has initiated probe against the likes of Amazon, Facebook, Google, WhatsApp, and other local digital players as well, and assess the issues like net neutrality, leveraging network effects, and collection of data, leading to the accumulation of market power in its merger assessment. Albeit a young regulator, I would say, as compared to its international peers, the CCI has been quick to adapt to the emerging issues of the digital markets, as seen in some of the decisions that I discussed in the presentation today. And I believe that there are proactive measures being taken and rapid developments in the realm of competition policy in India. And this is from Masako. These are the disposal rate of CCI as of like last year. You can see here the green channel matters, 51 includes 51 of them and has been disposed. I would say that there is a backlog, but quite efficient, I would say. And thank you so much for your time and patience. That's about it.